Welcome to this week's edition of the Gorry Show. I'm a solicitor in Enfield in County Meath, and I've got a YouTube channel with quite a few subscribers. I started doing this weekly show, so-called show, where I simply take a look at my law or legal related tweets on my Twitter feed and see is there anything useful in the cesspool that is Twitter. And quite frankly, from time to time, and indeed every week, it is possible to get stuff, links to material that is useful and that is helpful, and especially if you have an interest in law or business. I'm looking at my Twitter feed again this week. Today is the 28th of February 2020, and the big news today in the legal feed, and all I'm concerned about really is the legal situation and various bits of legal news, is the coronavirus outbreak and the first incidence of the coronavirus on the island of Ireland. A couple of questions arise in relation to, or from a legal perspective, from the perspective of being an employee or from the perspective of being an employer. One is the notion or the idea or the recommendation that you self-isolate for a fortnight or something when you come from an isolated or come from an infected area. That's all very well, and you must follow the legal or the health advice, the WHO advice, and the advice from the Department of Health and from the health experts. The employment law questions, however, that arise are: one, are you entitled to sick pay, for example, when you're self-isolating? What are you entitled to? What's the employer obliged to do? So you're at home, you're self-isolating, you're being very, very responsible, but the employer is down a member of staff, and perhaps you're a very important member of staff. Is he or she obliged to pay sick pay, for example? Are you sick? That's the question as well, because clearly you're probably not sick. You're taking the self-isolation procedure as a precaution, and you're doing it on the basis of the best medical advice. You're doing it in order to prevent becoming sick. However, will that entitle you to be paid, and will it entitle you in future to self-isolate in respect of any other diseases? Never mind coronavirus. What about other stuff that might occur in various exotic parts of the world that you might visit? Anyway, that's just a hypothetical question, but it's not a hypothetical question at the moment when people are being advised to self-isolate, and where obviously we have the first incidence of the infection or the disease on the island of Ireland. Second question arises is the question of GDPR and the disclosure of an employee having the virus. I heard the Minister for Health, Simon Harris, this morning on Sean O'Rourke programme, and he was being very, very circumspect as to what information he could or could not provide. In summary, he couldn't provide much information at all, and the question though arises as well in the workplace is, if an employee has the GDPR, has the virus, is there a breach? There probably would be a breach of the personal data right of that employee to disclose it to other employees. But the coronavirus, as I say, it's in the news, it's very topical, and it is giving rise to various situations from a legal perspective. I came across a very useful tweet there on the Workplace Relations Commission feed. The Workplace Relations Commission were doing some sort of a presentation or seminar someplace, but there's a link there on their Twitter feed to an employment record or employment records that the employer should keep. And it's actually a very useful link. It's a very useful guide from the Workplace Relations Commission. And if you're a small employer and you're not sure about your obligations, etc., this is a useful link, very, very useful link to set out exactly what you need to keep and the documents you need to keep and so on. And if I was concerned at all about having any sort of an inspection from, for example, the Workplace Relations Commission, I think it would be a good idea to have in place the recommendation or the recommended documents from the Workplace Relations Commission. I can't find it there now on my Twitter feed, but if you go to the, oh yes, I've found it there now. It's called the Employer's Record Log. But if you go to the Workplace Relations Commission, that's at WRC_IE Twitter feed, you'll see the employer's record. They're doing, I think, some sort of a road show or ISME are doing a roadshow, and it's obviously a very important document, very important link. It's very, very useful. I had a look at it earlier on there, and it sets out the various documents, the various records the employer should keep. I came across two very important or two very interesting cases as well during the week. One is to do with an Employment or an Equal Status Act complaint. It's the question of discrimination, and it's a complaint brought by a man, Mr. Walsh, against Allied Irish Banks, and he was complaining about the bank's use of particular video in on YouTube videos or in some sort of a marketing or advertising campaign. And it's something to do with a campaign promoted on YouTube entitled Abusive Teller Machine, where the complainant maintained that he found the publication to be grossly offensive to men. So this man brought a complaint to the Workplace Relations Commission under the Equal Status Act. The Equal Status Act deals with the supply of goods and services and allows you to bring a complaint if you claim you've been discriminated against in relation to the provision of goods and services. This man made a complaint to the WRC, and basically I think his particular complaint was that he found it grossly offensive to men. There was a number of preliminary issues, though, a number of legal arguments made by the bank, Allied Irish Banks. The first one was that he hadn't got the locus standi to bring the complaint, and this was on the basis that the complainant was not refused a service or treated less favourably in respect of any service. In other words, he hadn't actually been refused a service and hadn't experienced any adverse consequences or any adverse treatment in the provision of a service. He simply saw, I understand, without looking at the detail of it, he saw this campaign, saw the YouTube videos and so on, and took offence at it and said it was offensive to men. But the preliminary issue was the question of locus standi. There was another issue then that the bank raised, and that was that it was a claim on behalf of a group. So he was claiming to bring this claim on behalf of a group, but he had no actual locus standi to do so. And there's various jurisprudence referred to there where you cannot bring a claim on behalf of a group, and you cannot bring a type of a class action in Ireland that you might be familiar with from watching American TV. And finally then, there's the question of the preliminary matter regarding having a prima facie case. The bank also raised a concern with regards to the burden of proof, where the complainant must establish facts from which a reasonable inference can be inferred that discrimination has occurred. But the bank submitted that in accordance with the Act, the burden of proof rests with the complainant, which is correct, and as a preliminary matter, he must establish facts from which discrimination on the grounds of gender may be presumed. And the bank maintained that the complainant had not sought for, nor had he been denied the service from the bank, and therefore a prima facie case did not exist. So the very first thing you must do if you want to bring a case for discrimination, either under the Equal Status Act or the Employment Equality Act 1998, you must prove facts from which a reasonable inference can be drawn that you've been discriminated against. This fella couldn't do that because he simply took the hump at the YouTube videos. However, he hadn't been discriminated against, he hadn't tried to avail of a service, and therefore that was the argument the bank was making. Further question arose though, and that's an interesting one, and that is the question of what is a frivolous or vexatious complaint. And to say that somebody is bringing a complaint, if you were at the WRC yourself, you might say that such and such a person has brought a complaint that's frivolous and vexatious, etc. But like all things in law, the question of what's frivolous and what's vexatious and what shouldn't be heard is in legal terms defined from various cases and jurisprudence. And this case, interestingly, is a case which looks at the question of what is frivolous and what is vexatious, and the various cases that have looked at that. And for example, I won't go into it. The case is worth having a look at though. It's an interesting case, but the complainant failed in his case. The adjudication reference number is 00023225. If you go to the Workplace Relations.ie website, you'll be able to have a look at that case yourself. I just want to look at the final finding of it. and that is, I do not find in favour of the complainant and dismiss the complaint as being misconceived. And so the bottom line is the complaint was thrown out, but I don't think it was held to be frivolous or vexatious. In other words, I think the WRC did view his complaint as being made in good faith, as it were. He had genuinely held beliefs, and it was misconceived, but it wasn't frivolous or vexatious. I think that's the import of it. Have a look at the case yourself if you're interested in it. The other useful case I came across, and I'm after losing the link to it now, but it was an interesting case there, published by another firm of solicitors, to do with the disclosure of documents. This was an employment case. I had a quick glance at it. I can't find it now. I'm going to have a look again, see can I find it, and I'm going to perhaps do a blog post on it. But it was a case where there was either a redundancy or an unfair dismissal or a constructive dismissal. In fact, I think it was a constructive dismissal. The employee left, and the employee left in circumstances where he or she didn't exhaust the internal grievance procedures first and didn't exhaust all procedures available to him or her in the workplace, didn't look at the details. However, this case, the employee was still successful. The reason why was because the employee, having made a data protection request of the employer, ended up with emails which proved clearly that the intention of the employer was to get rid of the employee. So, notwithstanding the fact that the employee had not exhausted or used the internal grievance procedure, the WRC still held that it was in fact a constructive dismissal, because not only did the employee think that the employer wanted to get rid of her, she could prove it. She could prove it from the emails that were disclosed by way of the data protection request. Therefore, the advice from this particular firm of solicitors and the advice from a common sense perspective is internal documentation from HR, from various people, executives, managers, and so on and so forth. Really, if to do with other employees, you need to consider, you need always to be aware that the likelihood is that at some point you may have to disclose these documents, and they may well surface at a WRC hearing for some breach of an employment right, for example, constructive dismissal, unfair dismissal, discrimination, or whatever. But the bottom line is, in the creation of HR documents, you really should assume disclosure. You really should assume that they're going to be disclosed at some time later on in a dispute, and you're going to have to stand over them. So you need to be very mindful of that, very intentional and conscious of that when you're creating the documents in the first instance. I hope you find this video useful. If you do, give it a thumbs up down below. This is my weekly show, Terry Gorry. I'm a solicitor in Enfield and County Meath, do a lot of employment law, and this is kind of a whistle-stop tour of my Twitter feed, and that's about all I found this week. In my legal feeds, I have to get a decent feed there in relation to business and so on. Haven't got anything there at the moment. Hope you find this one useful though. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button down below if you're watching this on YouTube, and hit the bell icon and you'll be notified when I bring out a new video. Thanks for watching. Thanks for your time.